So we are going to also still look at the law as it was applied in the first workshop. However, once you drill to reading the learning outcomes, you will come to realize that the entire workshop, one, you've basically achieved one learning outcome. Okay, that is to say, matters concerning leases. Okay, but you ask yourself, which part of the workshop covers, okay, the rest of the learning outcomes? So when you read this workshop, you'll be able to realize that the rest of the learning outcomes are covered vehemently in workshop 2. Regardless of the fact that it still has some components of workshop 1, it is for purposes of appreciating the principles in leases. So as a result of that, allow me kick off the session. So who's going to take us through the facts? We are going to first deal with part A. Council Vanessa, are you in possession of the workshop?
Council, apologies, I'm somewhere. I can't read, but maybe someone else can take on.
Okay. Who can?
Can I read?
Yes, Council. Okay.
Can I read?
Yes, Council. Take us through part A.
Changweri Coffee Estates Limited has a
Now,
freehold title.
Whenever we are reading facts, remember in our previous workshop, we came to realize that we have different categories of persons who can own land. And we said we have two categories of persons. That is to say, natural and artificial. Under artificial entities, we have government entities and then companies. So when you are reading and realize that you're dealing with a company, first ask yourself, okay, once you see that it is a company, when you are analyzing the facts, look at its status. Is it a citizen company or a non-citizen company? That is going to give you the first step in appreciating what you're going to do with. Okay, so Council, now as you are reading, put it at the back of your mind that what you are dealing with is a company. So in your facts, just know things that the law prohibits when it comes to companies. Okay, let's proceed.
Changweri Coffee Estates Limited has a freehold title, FRV 15 folio 25, measuring 100 hectares.
Yes.
Land situated in Mubende district.
Yes.
Changweri Coffee Estates Limited was incorporated in Uganda in 1932 with 7 shareholders, all of them British nationals and citizens.
First stop there. Council, first stop there. They are all British citizens. Okay. So, but in which year? Yes, Council, in which year?
It is 1932.
1932. Look at when did the Companies Act come into place and the Land Act. We get it. The law doesn't act retrospective. Okay, we proceed with the facts.
Only 2 of the original shareholders are still alive, but elderly and living in the UK. The deceased shareholders' shares were transmitted to their children, who are all British. Changweri Coffee Estates Limited obtained freehold title in 1946 following the former owners, who were Italians, being declared an enemy estate after World War II.
Yes.
Changweri Coffee Estates Limited has owned the land to date, save for a few years in the 1970s. The company maintains a large coffee plantation thereon and a coffee processing factory. 2 of its directors, Britons, are resident in Uganda. The company has decided to dispose of the land together with the developments thereon by way of lease. The prospective lessee intends to sublease 58 acres where the factory is situated. Question 1. Advise on status of the land and ownership. Question 2. Explain the procedure on subleasing and legal import. And C. Draw the sublease agreement. That is all, Council.
So, colleagues, have you looked at those facts very well? What have you realized? What have you realized from those facts? Aha. Let's read. I'll show you something. Changweri Coffee Estate Limited has a freehold title. Okay? Has a freehold title. I want us to pay attention to this work, but I feel like the work has a mistake. Okay? That's why I told you the workshop has possible and impossible transactions. Okay? The fact saying that Changweri Coffee Estates Limited, KCEL, has a freehold title of FRB 15 folio 25 measuring 100 hectares, land situated in Mubende district. Okay? It was incorporated in that year with 7 shareholders, all of them are British nationals and citizens. Only 2 of the original shareholders are still alive, but elderly and living in the UK. The deceased shareholders shares were transmitted to their children, who are all British. KCEL obtained a freehold title in 1946. Okay, you see, it's a freehold title. So what does this mean? But the workshop is showing that there are 2 freehold titles. The title they have, they got it in this year, okay, in 1946. It is a freehold title, not so. But then the questions are talking about they want to dispose of by way of a lease, not so. But again, the questions are talking about subleasing. So I don't understand. You get the problem where it is. The land is a freehold piece of land. Okay? You get it? If we are going with a fresh lease, the facts could pass the test. Not so. But the workshop is talking about sub. So that means there should be an existing lease somewhere. Where is that lease? You've seen it. Members online. Okay. Have you seen what I'm talking about? Yes, Council Samuel, your hand is up.
Yeah, so my question is, don't they mean that the company wants to dispose of the land by developments there by way of lease? Then after that, the prospective leasee, that person who is available, please again wants to sublease.
That's another version of the workshop. Okay. Yes, Council Derek.
Yes, Council. We were actually given the honors of doing this task, and in regard to one of the discussions we were having with you, the fact that I don't have the act, anyone who has it can actually peruse to see section 26 of the Land Act. Is it 26? Forgotten the right section that says if a person loses citizenship, then definitely, or if they hold a freehold or a milehold title, definitely that's seizures. And if you look at our facts, they're saying that it became a freehold company when the Italians were declared an enemy state. So that means when these people regained it back, it went back to being a foreign company, and therefore their freehold terminated to a lease in that regard.
So we are going to analyze that. Okay.
Yes.
We are going to get there.
Yes. So, Council, that's all I can say on that, because that's what we came up with based on that section.
Okay, we are going to go there.
Yes.
Any other view? Yes, any other view, colleagues?
If you look at the question, yes, advise on status of land and ownership.
So now we want to start, okay, on advising one on the status of this land. So when they ask you on the status of this land, what answers do they expect? Okay. Is this land still owned in freehold? Is it owned in mile? If it is it held in a lease? If it is in a lease, is the lease still subsisting or not? Okay. If it was initially a freehold or mile, was it converted into a lease? How? By operation of law or by an agreement? Okay. So it is a case-to-case basis. So when you get to our facts, okay, when you read paragraph 1, it shows that the company existed in Uganda since 1932. Okay. However, since 1932, the company had not yet bought any property in Uganda. So the company started owning property in 1946. So the first property they owned is a freehold title FRB 15 folio 25, measuring that, okay, which they took over from the Italians. You get it? So literally, we have one title that they are talking about. But the question is, when you read paragraph 2, okay, they said they obtained a freehold title in 1946 following the former owners, who were Italians, being declared an enemy state after World War II. What does that mean? Okay, what does that mean? Remember, Look at these years. Were we still under colonialism? Okay. So what does that mean? We were all subscribers. Okay. Open the Land Act. In which year was it enacted? Okay. The Land Act, its commencement date. So the Land Act is of 1998. What does that mean? The provision of that once you lose citizenship, you cease to own that land doesn't apply from the Land Act. Okay. So Council referred us to section 26 of the Land Act. Let's open it.
So it's section 40, subsection 6, eh?
Section 40, subsection 6.
Yes.
But that provision, that's why I was asking you the commencement date of the Land Act. The commencement date of the Land Act. Does the Law Act? Council, you get me now?
Yes, Council. I'm on the same page now.
So what they want, they have told you the company still exists. Okay, the company still exists. So the question they have, they want you to determine is ownership of this land. Okay, whether this company can own this land in freehold. Okay, that's why they told you they have owned the land up to date. Okay, look at the nature of that company. Does it pass the test under section 40? That means after commencement of the Land Act, okay, whatever is against the Land Act is null and void. So look at the status of the company. Is it a citizen company? Okay, is it a citizen company? So it is owning freehold. That's why they're telling you advise on the ownership. You get it? Okay. You can apply that law, but it needs logic for you to be strategic. Okay. You get it?
And citizen.
Okay. So you couldn't apply the section. They gave you a word in this paragraph, okay, which says that. So read section 40, subsection 6. That's what you have to first look at the when the company came into place, when it acquired land, and when the Land Act commenced. Okay, Council, you get it where why I didn't go direct to that provision.
Yes, Council.
Yes.
Land Act.
Council.
Yes.
Council.
Yes. Yes.
My interpretation of this paragraph 1 and paragraph 2 is I'm going to first address paragraph 1. Paragraph 1 is saying that these people, by 1932,
the company was in existence. Yes.
To me, by that time, they were having a leasehold onto this land. But in 1946, when these people were declared a state enemy, remember when a country is declared a state to another, all contracts cease there and then. So when these people cease their relationship, this company we are dealing with comes in and then takes the leasehold from there. That's how I'm kind of interpreting it.
Okay, let's take it at this pace. Facts of part A, paragraph 1. They say Changweri Coffee Estate Limited has a freehold title. What does that mean? Currently, they have a freehold title. That's what it means. okay, they have a freehold title, but the subsequent content, they are giving you the status of the company. Okay, that this company, Changweri Coffee Estates Limited, was incorporated in this year. It has this number of shareholders and what have you. But what that paragraph is, that the company we are talking about, which had 7 shareholders, all of them were British nationals. Okay, currently it is having a freehold certificate of title. That's the meaning of paragraph 1. But now in paragraph 2, they are showing us how the company came to own the title we are talking about. That formerly, this title was of Italians who were chased out of the colonial government because, okay, they are declared to be enemies of the British Empire. So that means if the Italians went out, then that's when Changweri came to occupy that land that we are talking about. Okay, are we together?
Yes, we are. Thank you.
So now, paragraph 3, they are telling you.
Councillor Rashid.
Yes.
Excuse me, Councillor.
Yes.
So have you looked at section 40, subsection 5? Because when you trace back the history of this land, by the virtue of 1975, all land was declared public land and it was put under what? ULS. It
Yes.
land commission.
Yes.
And all people were supposed to hold land as a lease. But when you look at section 40, subsection 5, is the effect that for avoidance of doubt, any non-citizen who immediately before the coming into force of the Constitution held land as a lease on conversion within the meaning of the Land Reform Decree 1975 shall be deemed to have continued to be a lessee in accordance with the conditions of the lease. So, Council, what's your input on that? Because, in my opinion, if these people were holding land from 1946, then they went through the changes of the 1975. And by the import of this section, it means that all those people who had a lease by the virtue of the 1975 shall continue to hold the lease even after the Constitution has come into play. There was no need of converting it into other land tenures. Because if we maintain the standard that it's a freehold, how are they going to convert it into a leasehold? Because this section seems to be suggesting otherwise, but I seek to be guided, Council.
We are going to interpret all the provisions. Yes, Councillor Nanteza. Okay, so now let's read our facts. Okay. In which year did this company acquire land? 1946. Okay. So by 1946, all of these laws were not into place. Okay. And that means these guys were okay to hold their freehold certificates. Okay. But now, do we have the law, the Land Reform Decree here? Okay. Can some ever come across the 1995 Land Decree? 1975 Decree. Okay. So when you look at that, okay, when you look at the years, because the gist of interpreting this paragraph is in years. That's why they gave you a series of years. Okay. Why? During that period, there are a number of sequences that kept on changing in land ownership. Okay. So One, we had the 1975, okay, land decree, which land became. So, unfortunately, I don't have the theory. Banaye tetulina ako yaliko ku gavumenti ya Amini atuyambe. 1975 land decree. Okay, members, hold on a bit. I'm getting the decree. Okay, a brief of that decree says that accordingly, actual addition affecting the land of Ankole, landlord apply appointed approval, avoidance of doubt carried, chairman, charitable organization, the chief justice, commencement commission, conditions imposed consists, construed continued contrary eviction to create customary tenure, decided decision, decree deemed economic effect, encumbrance, enforced 5,000, granted guilty. As have you got it? I got here to put something else. Doesn't open. It is encrypted. Okay, so but let's get back. So when we look at our section 40, okay, subsection 5 and 6, in the first place, okay, in the first place, when you look at section 6, section 40, subsection 6, it says any citizen. So first ask yourself in the first place, is this company a citizen company or not? Okay, before, because we are disqualifying the laws. When you read section 40, subsection 6, it starts with the word any citizen. So has this company ever been a citizen of Uganda? Yes? Members online, has this company ever been a citizen company?
No, Council.
So can you proceed with section 40, subsection 6 in that sense? Because it says, okay, any citizen holds land under freehold or mild tenure and who seizes. So what does this imply? Okay, has this company ever been a citizen company? Okay,
Council Rashid.
Yes.
Council, hold on, there is a screenshot I've displayed.
Hold on, Council,
Yes.
hold on. Okay. So does section 40 subsection 6 apply? Okay. Does that section apply? Because it says any citizen. This company has never been a citizen company. But by virtue of the years, the laws we have do not act exactly. So by virtue of that, section 40 subsection 6 cannot apply. So we are off. Okay, so now which law is turning that freehold into a lease? Okay, are we on the same page? Yes.
Yes.
Okay, we are going slowly. Why? We want to go on disqualifying different provisions of the law. Okay, and we come to consensus that this law does not apply and this law applies. You've said it. I'm not saying it. Okay. So now let's read the law reform decree. I'm forwarding the same as well. Not yet. Okay, so let's read it. Okay, so Judith has shared a copy of the decree. Let me show them. Okay, she has shared a copy of the reform decree. So we want to see how did this decree affect, okay? When you look at section 1, okay, section 1 of the law reform decree of 1975 says that decree to provide for vesting of title to all land in Uganda in trust for the people of Uganda to facilitate the use of land for economic and social development and for other matters connected therewith. With effect from the commencement of this decree, all land in Uganda shall be public land and be administered by the Commission in accordance with the Public Land Act, subject to such modifications as may be necessary to bring the Act into conformity with the decree. Without then subsection 2, without prejudice to the generality of subsection 1 of this section, the following of the decree shall have effect with respect to tenure and use of land in Uganda. Subsection 2, it is section 2. There shall be no interest in land other than land held in the commission, which is greater than a leasehold. And accordingly, all of freeholds in land and any absolute ownership, including mile ownership, existing immediately before the commencement of this decree are hereby converted into a lease. That's the provision I wanted. Okay, so what does this imply? If in our facts, these guys obtained this freehold in 1946, okay, so that means in 1975, okay, because the commencement is September 1975. So that means in September 1975, this freehold ceased to exist, okay, and it became a lease tenure, okay. So now after reading that decree, then you come to the Land Act. Do we have the law in the Land Act that upholds the position in the Law Reform Decree. Then you come to section 40, subsection 5. Okay. In the decree, we've read section 1, subsection 1 and 2, and then section 2, subsection 1. Those two sections in the decree, they converted the entire land, and they said mile and freehold were cancelled. That the only tenure was supposed to be the lease tenure. Okay, so now what does this mean? In 1975, this company was not a citizen company, so the entire freehold they had was converted into a leasehold. Okay, are we together? But remember, by 1975, this law didn't give the ultimate number of years of a lease. You get it? So that means this guy had a lease, but it was unlimited, literally. Okay, so then that's when we are going to adopt section 40, subsection 5, which says that for avoidance of doubt, remember we said whenever you meet a section of the law with the word for avoidance of doubt, notwithstanding. Okay, so for avoidance of doubt, that means okay, so the section says for avoidance of doubt, any non-citizen, you get it now, was our company citizen by that time? So they fall under any non. So the reason why we can't apply subsection 6, it starts with a citizen. Subsection 5 starts with a non-citizen. Okay, you get it? So says any non-citizen who immediately before the coming into force of the Constitution, coming into, okay, held land, okay, the coming into force held land as a lease on conversion within the meaning of the Land Reform Decree. So that does this mean if these guys occupied this land in 1945, in 1975 September, as per section 2 and 5 and 1, that freehold was converted into a lease. Okay, so now subsection 5 came to restrict that lease, to recognize it. Okay, so it says on conversion with the meaning of the Land Reform Decree shall be deemed to have continued to hold a lease for 99 years. So what does this mean? Okay, what does this mean? You get it? Okay, so the decree didn't limit the time. Then section 40 subsection 5 limited to, but ask yourself the 99 years, when did they start counting? You get it? Okay, for 99 years from the first day of June 1975. So now they told you to advise them on the status and ownership. You get it? So now you come ownership, the company still owns the land, but under a lease tenure. Okay, by virtue of section 1, 2, and section 4, section 1 and 2 of the Law Reform Decree, and section 40, subsection 5 of the Land Act. Okay, so now we want to go to the status. Is the lease still continuing, or
Is it that they own the land?
okay, the company still owns the land?
Hello.
Okay,
Mm.
are we together? Okay, so now
By virtue
by virtue of section 1 and 2 of the Law Reform Decree, and then section 40 subsection 5 of the Land Act.
Council.
Yes.
Now, I'm getting a little bit confused because in paragraph 2, they're telling us that the company owns the land
to date, save for a few years in the 19th, we are seeing it became a lease. Then there's also, so I'm getting confused around there because they told us that it lost the land around the 1970s, and that's the time we're again seeing that it turned into a lease. I don't know.
Yes. So you have to, for them, they think their freehold title is valid. That's why you have to first advise them. You get it? Okay. Now you tell them the truth that in 1970s, your land ceased to be freehold. So the freehold title you have is fake. The right thing you have is a lease. And it happened by operation of law.
So you told them?
You get it? For them, they're telling you that they have a freehold certificate of title. Okay? But I've given you the scenario that there is a time when where they ceased to own that land in 1970s. Why? All people lost ownership in 1970s by virtue of the decree. Okay? By virtue of the decree, everyone lost ownership on land. Until the 1995 Constitution came back and revived that position. So that's why for them, they think that they have the right title. Kumbe the title is fake.
So this is you advise them that.
Okay, so you tell them, okay, that they ceased to have a freehold title which is valid in 1975 September. If even we could tell the time when it came out, we could tell them. Yeah, because the decree cancelled all mile and freehold titles. All they are declared null and void. Under section 2.
1975 September.
Okay. Yes, you lost. Section 2 of the decree cancelled out all freehold and mile titles. They said the only tenure that had to exist was leasehold. And when the Constitution came into place, it revived that position. That's why for them, they think their freehold title is what? So that means these guys kept the title in their houses. Okay? Remember, their lease was by operation of the law. You didn't even supposed to have documentation. The law provided. So now, after the Constitution coming into force, they came out with their freehold title, thinking that it is valid. Okay? Yet it ceased to be valid by that time. Okay? So, are we together now? Okay? So now, let's look at the years. So their lease is of 99. Its commencement date was June 1975. So you count from June 1975 up to date. How many years have they consumed out of 99? Okay.
This is 2023. Minus
1975.
Yes.
So they have consumed 48 years. So that means their lease is still valid. Okay. They are still valid for their lease is still valid for how many years? 51 years. Okay. So what does that
Council?
mean? Yes.
Council, do we begin?
We begin counting from 1975.
Because people who had the land right from when they obtained their freehold.
Yes.
Why are you counting from 75?
The law, that's what the law says. Section 40, subsection 5. Just read it. It says you should start counting from 1975 June.
Okay.
So, are we together? Okay. So now because the biggest challenge with that was interpreting how it turned into a lease and what time. So if they still have, that means it's a lease and then they can sublease. But ask yourself, does the law allow them to sublease as well? Okay. And besides that, remember their lease converted by virtue of a statute. Do they have a lease type? You get it? So when it comes to procedures here, they have to first obtain a leasehold certificate of title from where? Uganda Land Commission. Remember, the commission is going to give them a lease agreement. You first read through the conditions. Are they allowed to sublease? You get it now? If they are allowed to sublease, okay, you're going to presume because they want you to sublease. Okay? But it is ekibaddewo kutegeera bajja batya okubanga balina lease nga okay? So they have to first obtain a freehold, a leasehold certificate of title from Uganda Land Commission. Then, two, they peruse the lease agreement, obtain a certificate of title, a leasehold certificate of title from Uganda Land Commission. Then they have to peruse the lease agreement to ascertain whether they have a right to sublease. Then they will proceed and execute a sublease agreement. A sublease agreement. Proceed to execute a sublease agreement. And then they register it. Can a sublease register? And they get a sublease title.
Why do they have to go to Uganda Land Commission? What divide nature?
No.
So a sublease, you only stop at a lease agreement, you don't get a title. And when I sublease you, they don't give you a lease certificate of title. Just stop in this agreement. So that's why your part A stops on an agreement to sublease. Let's go to part B.
But Land Commission.
By no survival.
What?
Uganda Land Commission, Yelesa.
Why?
The owner way it was land vested into the government by virtue of the 1975 land decree.
By then.
Okay, so let's go to part B.
Councillor Rashid.
Yes.
Who will be the leasee?
The leasee. The facts I've given you. The company has decided to dispose of the land together with its development. They are owned by way of a lease. The prospective leasee intends to sublease 58 acres where the factory is situated. Okay.
Okay, thank you.
Okay. Simple as that. Let's go to part B. Who's reading part B for us? Council Aisha. Council Aisha Nakazi. Read for us. Okay, Council, you can read. Part B.
The part B. Gongomo
Yes.
Box Uganda Limited, the company, is a company incorporated in Uganda with 100% Ugandan shareholding.
We first stop there. As per the provisions of Section 40, they've told you 100% shareholding Ugandan. What does that mean? The controlling authority is in Uganda. So that means it is a citizen company. We proceed.
The company owns land in Bungoko measuring 100 hectares. 100 hectares and maintains a vibrant and enviable tea plantation thereon.
Yes.
Part of the company's land measuring 50 hectares has been identified by the ministry in charge of energy and natural resources of the government of Uganda as a suitable location to construct a power substation. The substation is intended to supply the much needed electricity in the eastern and northeastern parts of Uganda for both domestic and industrial use. The Uganda government is determined to have the land by November 2023 and hand it over to the Chinese company that is going to execute the works.
We did this part on Friday. This is what we call compulsory land acquisition. Okay? So, you will start with Article 26, okay, which says that all persons have a right to own property, because they have told you, advise the company over its rights in the intended takeover of its land by the government. So the first right is a right to own property. That's their right, okay, under Article 26, okay. Then the same article says that no person shall be deprived of his or her land without adequate compensation. So the second right is a right to be compensated. Okay? The second right is a right to be compensated. Okay? Then you go to the Land Acquisition Act. The Land Acquisition Act, it also has a right. Which right is that? A right to receive a notice, a right to be notified of the takeover. Okay? That is under section, is it 2 or 3? I'm looking at for that act here. It is called the Land Acquisition Act. Let's see it here. Okay. Yeah, okay. So when you look at the Land Acquisition Act, it gives this person some rights, okay?
It's
So
number 21, Council.
Okay?
It's number 21.
Okay, yes, I've seen it, okay? So when you look at section 5, notice to persons having an interest. So you get it. So the owner of this land has a right, section 5 of the Land Acquisition Act, okay, has a right to be given notice. Okay. Then another right is under section 6, a right to make an inquiry in the award. Once the government makes its own analysis, okay, and they give you for them what they think is sufficient. Okay, because they do their evaluation. So when they make the evaluation, they give you the award where you will take this amount. So you have a right to make an inquiry. How did they come to the conclusion that this is the much I'm supposed to earn? Okay. Yes, 5. Okay. It is section 6. Okay. So those are the rights. Then they are saying that the procedure, okay, under B, okay, the procedure, the way you see the sections in this act from section 2, okay, from section 2 up to section 7, that is the procedure. In order, you enter into, you take samples, you declare, you give notice, you give evaluation. The way the sections are arranged up to section 7, okay, the Land Acquisition Act, the way the sections are arranged, section 2, 3, 4, 5, 6, 7, that is the procedure. In order, mark that. So it shouldn't stretch much. Okay, but when you are handling that task, it is prudent, you take sufficient time, you write on what we call compulsory land acquisition. Okay, write about it, define what amounts to public interest, because the ultimate condition is that the government to acquire land should acquire it in public. Okay, so you ask yourself what amounts to public interest. Okay, I think we have a case here. Let me see if it's there. That LDC case. Okay, what amounts to public interest? Okay. Okay. I'm not seeing the case, but it is someone versing the Law Development Center. Okay, that case clearly explains what amounts to public interest. In that case, it was defined to mean, okay, you can just punch in High Court cases on compulsory land acquisition. If that case is going to come, let me try to get it for you here. Sorry, is the first one. But we have a recent one in Impigi. This one of the tree.
Excuse me, Kaz.
Yes.
Is it LDC versus Waswa Selufusa? Is it the one?
Yes, exactly. Yes, LDC. The first cause is that one you're talking about. I think, is it an appeal?
Let me cross check.
It is the Law Development Center versus Waswa. Something. Okay. We have another one of Goodman International Limited versus AG. Goodman International Limited versus AG and Luwero District Land Board. That case discusses what amounts to compensation very well. Okay. Okay. What amounts to? Yes. So look at it very well.
Excuse me, Council.
Yes, yes, Council.
And so you talked about section 6 about right to make an inquiry.
Yes.
Can't I refuse?
Once you refuse, government will go on and they construct. You've seen roads where they construct a half and go until you sort yourself. Simple as that. Many. You the person who made an inquiry, like they're giving you little money. Okay. So now, once you see things, just have you give you the command and eat and go. These are 3 things after all. Okay. So let's go to part C. Yes, council, take us to part C. So the workshop is C. Okay. Who is taking us through part C? Council Joy, are you there?
Let me volunteer.
Okay.
Kafelo, a very affluent businessman in the year 2014, brought from a one Pantalewo a third of an acre of land. Kadondo, block 254, plot number that, on the fringe of Muyenga, bordering some slummy areas of Namuwongo in Kampala district. He developed a state-of-the-art mansion facing the lake with a very beautiful to kill for panoramic view. However, in September 2022, Pantalewo decided to sell the other 2/3 of the residue to Kongolosi Nkufele, a man loaded with lots of money whose source is not known but highly suspect. Kongolosi is currently putting up a skyscraper completely and literally killing Kafelo's panoramic view. Further, Kongolosi has blocked Kafelo's access road to the public way, claiming it is on the part of the land he, Kongolosi, bought from Pantalewo. Kongolosi has refused to listen to any suggestions of negotiations and has even threatened to deal anybody who dares to touch any inch of his land, as described in his title, Kadondo, block 254, plot number, that one. He even syndically advised Kafelo to find his way through the Shanti Namuwongo houses. After all, they are boarding his land. Analyze and advise Kafelo his rights over the panoramic view and the intended blockage by Kongolosi.
Hey, now, I love land law. You don't grow old. In our first term, we looked at what we call rights on land, above and below. Okay, above and below. This guy is constructing a skyscraper, and this skyscraper is blocking someone's panoramic view. What does that imply? This person is trespassing where? Where?
In the sky.
In the sky. Okay. We have a famous case of a tobacco company which raised a signpost. Okay. 10 meters feet above, okay, someone's house, and this person was sued for trespass. So you studied your land law. So they want you to
Excuse me, Councillor Rashid.
Yes.
Okay, I request to be guided. For me, I don't see it as a trespass, because probably this person is also building in their own space, basically, but they are only blocking the way. to, is it called, it's more like an easement, something like that. So I don't see anyone trespassing on anyone's property here, but probably they are interfering with either passage of light, passage, there is a lot of things, passage of, like, he cannot have his view properly. But I think this person also bought the land and is also building on his own piece of land. Thank you.
Yes. Okay.
I don't know, but there is a book I was reading when I was at undergrad. They had a study. They said even when you're building a flat, like you find an area where the flats are like on, let's say, 4 floors, you don't come and you start building on the 6th floor to block their view. They were giving such a scenario. So trespass like extends to that extent. I'm in agreement with the submission.
Yes. Are we together? Okay, so Council, when you look at that, yes, there's some element of trespass in the in the sky. Okay, however, the emphasis we are dealing with here, they want what we call blockage to access roads. So the question you need to ask yourself first, what amounts to an access road? Okay, you saw Professor Kanyehamba fighting for an access road. Najja natekako pesta yake sisi inaziva akapandika omusajja. You joke with the access road, it has power. Okay, so you ask yourself, okay, what amounts to an access road? When you read the Roads Act, okay, section 3 defines access road to mean a public or private road affording access to a public road or to a highway. Okay, section 3. Okay, so look at our facts. Was this the Roads Act, section 3? Look at that. What was this? What was blocked? Is it the access road? Because he can't access the main road. Okay, so by virtue of that, ask yourself, how can this person get access to that road? Okay, then you proceed and go to section 60 of the same act. Okay, section 60 of the Roads Act. Yes. Okay, section 60 of the Roads Act. The first law used section 3, okay, to define what amounts to an access road. Then we came to section 60, which says control of points of access to public roads. Okay, then after reading that section, you have to read section 60, 61, and 62. Because that is the one that talks about access to roads. Okay? 60, 61, and 62. But for purposes of the workshop, we want this person to get the access road. So that means this person has to make an application to construct the access road. Okay? So we shall proceed under section 62, subsection 1, which says that application for leave to construct access road through private property. Okay? Through private property. Yes. Okay? Through private property. Okay? Section 62. Yes. Okay. So we come, it says that where the owner of any land is unable, through negotiations, to obtain leave from adjoining landowners to construct an access road to a public road, he or she may apply to the minister for leave to construct an access road over any land lying between his or her land and the public road. So, okay, when you read section 62, subsection 1, it gives you the conditions upon which you make an application to construct a private access road. The first condition they are giving us that where we should be one, the owner. So is your client the owner of the land? That's one. Then 2, okay, you are unable. Okay, you are so is your client able to access the main road? Then 3, negotiations have been tried, but they have failed. Okay. Yes, you've tried to negotiate with the neighbors, but the neighbors have refused. So come to our facts. Yes, they have refused him to utilize it. So it comes to our facts. The guy said, okay, has refused to listen to any suggestions of negotiations automatically. Okay. That means negotiations have refused. So that means your client has the 3 grounds that warrant him to make the application. Okay. So now ask yourself, okay, where do you make the application? To the minister. Which minister? You come to section 3. Okay. I'm very sure it defines the minister. Okay. Where is it? Which country? Oh, okay. It defines a minister to mean the minister responsible for roads. Okay. Okay, to mean the minister responsible for roads. So you are going to address your application to the minister. But the question is, how do you apply? When you look at section 62, subsection 4, subsection 4 says, an application under subsection 1 shall be made in the manner prescribed by the regulations. So the question is, yes, the question is, do we have the Roads Act regulations or not? If we don't have the regulations, that means the application is made by an ordinary letter. Okay. So are we together? So are we good to go to part D? Yeah, it's by an ordinary letter. We have them. I'm not seeing them here in this. But when you look at the regulations council you are referring to, that section just says that the minister may, not so? It gives the minister power to make regulations, not so? But are you having them? Okay, we don't have regulations yet. Okay, so we shall move by an ordinary later. Any question, colleagues? This workshop is simple.
Are you joking? Serious? Yeah.
So you guys want to strike, eh?
Hey, family is out. On a Tuesday, the Monday. Hey, 2 minutes.
Okay, so let's go to part D.
So I have a question before you can proceed.
Yes.
The question, when read properly, it says analyze the device Kafero's rights over the panoramic view and the intended blockage by Kongolasi. What rights could Kafero have over the panoramic view? Because I think this question is 2 in 1.
The right, that's what we discussed first. We said, remember the panoramic view, it's above, eh? It's in the sky. He has a right. That's when we said that when you look at our first term work, okay, it had that element, rights of above and below. So here you had to look at rights above. That's what we call trespass in the space. It is a tort. Okay, so then, and the intended blockage, the question is, do these guys have a right to block him from accessing the same? Do they have a right? That's why the law goes ahead to give you a right to apply if this person has blocked your way through. Okay.
Council.
Yes.
I'm also not understanding, because 90% of the students right now, they're basing themselves on Eastman. So I don't know if you can differentiate between the trespass you're talking about and the Eastman. Because I read somewhere that provide that Eastman can also be like when someone maybe blocked your view, someone blocked maybe the light. Those are the things I saw somewhere in some case. So I don't know if you can differentiate between the trespass you're talking about and easement.
And so what is an easement? Yes, that's what is an easement.
Easement is the right to use someone's land.
What is land?
Land can be defined as anything under, above, or on the surface.
So when you look at the Land Act defines land, okay, the miswages, okay, below and above the earth's surface. Is the sky above or below?
It's above.
So if I trespass, okay, in the sky, that reasonable height, I'm going to be blocking, okay, utilization of your land. Is it not trespassing in your easement?
Council, excuse me, Council.
Yes.
Okay, for me, for trespass, we can't, because one of the things why I was insisting it's an easement, someone should read the case of Wildon versus Barrows. Why I'm insisting that it could be an easement, it is simple. If these people each owns land, they was, okay, like they bought land from, I think, the same person. So what would have been trespass would have been that if I have erected a skyscraper or skyscraper, it is somehow interjecting in the aerial surface of your land. But I am constructing this skyscraper in my land. Much as I'm going upwards, I have not entered an inch in your land. I understand we are talking about land being on the surface, below, and then above. That example of the man who put a signpost above, it entered into the neighbor's land, neighbor's aerial land by some inches, and that is why it was termed as trespass. But this person is building in his own land. He's not trespassing anywhere. I think we just have to clear out that. Thank you.
Yes. Okay, it's okay, Council. Any other suggestion?
Council, from the discussion we had with Balinda, I think on Saturday, he hinted on some of these things as common law rights that any owner of land has.
Yes,
that is the category he brought them in. And in his submission, he said that if a person buys a piece of land and he has bought it for the exact reason of having this view, and then at one time you come and block this view, you're actually infringing with that person's right. So it's a common law right, like quiet possession and maybe any other right that might accrue by reflection of the common law that need to be observed. So me, I'll take it in that angle.
Okay, but basically these are just common law principles, okay, that we are trying to put across everything's there and there. Okay. Okay, are we together, colleagues? Okay, Council, we proceed. Okay, so have we the other part of the roads, the access road, is it fine? That one is okay. So should we go to the last part of our workshop?
Council, I would seek more guidance on because I'm still having a little confusion in trying to appreciate section 64, subsection 3, in enforcing the right to having an easement. Because when I read it, it says a road authority or any person authorized by a road authority may remove or demolish any obstruction or any dam referred to as under subsection 1. So, and you're saying to apply, does it mean we have to first apply to remove this, or we remove it, or it's me who actually got this information in another way around?
Now, when you look at what we are basically interested in, okay, not getting the access road, okay. So if this person has put anything in the access road, okay, if this person has put anything in the access road, don't you think it should be first demolished?
So by my interpretation of this section of the law, I think it empowers any person who has come across any of these obstructions So it empowers that person to do the demolition or removal. And I was actually thinking that if I do that, then why would there be need to apply?
But remember, this guy doesn't want you to use, even if you demolish, this person will construct something. Not so? Again. And even if you demolish, okay, at your own, it will require some other extra energy. So to me, what I think, it would be prudent in your application, you also attach proof of this person having constructed something that is amounting to an obstruction. That's what I would think. I don't know what is the view of other people. Yes.
Council.
Yes.
I think every building must have been approved in this scenario. So if I have submitted my building plan for approval on my private land, and the planning authority has approved my structure, how can again someone come and say that I have obstructed this person's view?
Okay. No.
The building that has been approved.
But Council, we are Ugandans. We always deviate from the law. Okay? We always deviate from the law. And you've also done the same at a particular time, and you are intending to do the same at a particular time. Because we are Ugandans. Okay.
Okay.
Yes. Okay. So let's go to part D, colleagues, and we call it a day. Someone to take us to part D.
So let me take you through part D.
Okay, okay.
Part D. Kalungungu owns a building on Kampala Road, Road 1501, developed with a 3-storied commercial building under title LRV 9005, folio 10. This is a lease granted by the then Kampala State Council in 1969 for 75 years. But Kalungungu wants to sell the property and retire in his home village in Kidera, Kaliro district. All the 3 floors and the veranda are occupied by various persons dealing in various businesses. The 3rd floor is occupied by one company known as Kapelo Byong Advertising and Marketing Company that has agreed to purchase the property from Kalungungu at Uganda shillings 3.5 billion. However, the purchaser company insists that it can only pay 1/3 of the purchase price and the balance when the building is cleared of all the occupants as described here under. The 2nd floor is occupied by 10 tenants, and each of them pay their rent a year in advance. They have already paid for the year 2023. The 1st floor has 15 tenants. 10 of them pay rent 3 months in advance, although 2 of them are in arrears since April 2022, claiming COVID-19 related business failure, but still occupying the offices. Then the other 5 pay 6 months in advance. The 1st floor has a wide corridor between offices, and Kalungungu allowed his younger brother, Ngajaba, who graduated with a degree in industrial art and design in 1989, to display his artworks and generally carry on business therefrom. He has been operating from this place for the last 32 years, and his business is booming with many customers used to this as his address. Ngajaba is not married to and does not pay any rent to his brother. On the ground floor facing Kampala Road, there are 5 retail shops whose occupants pay rent a month in advance. On the veranda, there is a mobile money kiosk operated by a one Pesamingi who pays some minimal fee of shillings 200,000 every month to Kalungungu for being allowed to operate therefrom. On the same veranda, there Salon, the news vendor who operates therefrom since the year 2004 with 2 news stands, but also sells some other miscellaneous things like face masks, sweets, pens, and the like. Salon does not pay any rent for operating therefrom. KCCA law enforcement usually harass his and confiscate his goods. Part A. Analyze the different interests and or rights of the different categories of occupants of Kalungungu's building. Part B. Advise Kalungungu on the procedure and legal requirements to have the various occupants vacate the building.
Okay, so basically, this is the most interesting part and the simplest part. Reason, it is dealing basically with what we call tenancies. They have given you different facts setting out different types of tenancies. So you should be able to tell that this part has this type of tenants and these are the rights that this tenant enjoys. Okay. So in the instant case, we have what we call, hope you guys have ever heard of the following tenants. We have a tenant at will, a tenant at will. Okay. A tenant at will. Okay. Okay. Tenant is the person. Then the process is called tenancy. So you can say tenancy at will. Okay. This is the type of person. Okay. Who is there when the face of it is a tenant, but this person does not pay rent. So that type of person doesn't require a notice to leave. Okay. Doesn't require a notice to leave. So you just wake up and sit down. But again, so a tenant who doesn't pay rent is a tenant at will. So you don't enjoy a right of notice. So you check, require a notice to leave. Yes. When I'm selling off the property, never see Mugamba Dynamo. Okay, so you get it now. So the brother should know where he's going. Okay. Then you have another category known as a tenant at suffrage. Okay. A tenant at suffrage. Okay. This is a tenant who has made the landlord suffer. Why? Delayed payment. Okay. Delayed payment. The moment you are a tenant, a periodic tenant, okay, and the period upon which you're supposed to pay rent expires, or your periodic tenancy expires, and implying nothing takes place, you become a tenant at sufferance. You've made the landlord suffer, so the day one year, the landlord has the right to chase you without notice. Already you are in breach of the tenancy agreement. So I can chase you at any time. You've had tenants here who are in areas. Okay? So when you look at them, they should go. Okay? Then the last category is known as the periodic tenant. Okay. Periodic tenants. This is the type of tenants where you pay rent. If you pay for 1 month, you deserve a notice of 1 month. If you pay a notice of 3 months, they should be given a notice of 3 months. If you pay rent for 6 years or 6 months, it should be so. The period you pay, that upfront payment, is the number of days you receive your notice. So you count your facts. We have those who pay 3, we have those who pay 6, we have those who pay monthly. So those are what we call periodic tenants. So since this guy wants to sell off the property, he's supposed to give them notices according to their, okay, according to their periods. Okay. Yes. So the workshop is done. Very simple. The Waganda sekuzanya na korachi na kwaga. Okay, huh? Okay. Advice on the procedure and legal requirements. Okay. Yes, the procedure one write for them a notice. The legal requirement notice. That's what they want. And you draft the notice. They want it drafted. You draft and serve. And remember the time you serve them the notice, you're not supposed to pay rent. I will take it the last I'll take it. Yeah. And now, counsel for the week. I want you to look at what we call, when you look at that workshop, it says, use the facts in workshop 1 part C1 and advise Kahiri to secure his rights, okay, from the intended. What does that mean? Intended take over that physical. How do we call that physical possession in the law of leases? Is it forfeiture or re-entry? Okay, think between those lines. So the remedy, chances are high it is released against forfeiture by notice of motion. Think between lines before you draft your claims. Read the Judicature Act, is it section 25? Read it very well and see how it applies. Chances are high that is the gist of everything. Okay, so counsel for the week. Make sure you look at that. Any question before we call it a day and we go and rest? And maybe, guys, congratulations, you've received your family workshop on time. Okay. Those who want to be successors in their parents' estates, this is the week you're going to study how we steal wills, how we alter, how we change the wills. Okay. Counsel for the week. Make sure in family week you know how to draft a claim. Okay, because chances are high you're going to be arguing an application for variation of the will. Okay. Which workshop is that?
What document?
Council.
That's not with
Council.
This plaintiff works for the
Council Rashid, I have a concern.
Those are going to be annexed as counsel. Those I know. You are vacating a caveat counsel. I have that. I've never done that before. I caveated someone's letters of administration. They went for mediation. Let them file a main suit. So you're going with the way of. So you want to vacate a caveat for grant of letters of administration. Okay. Answer for the week. So yes, counsel, you had a question. I'm back this side.
Yes, counsel. My concern was yes, the first thing that we looked at, because I'm part of the team that is counsel of the week,
Yes.
We looked at that point of application where we have to go with a notice of motion supported with an affidavit. It's not in contention, but the only confusion comes in when they tell us it has to be an ordinary suit. So
then
you
that
can't.
means if it's an ordinary suit,
yes,
I have to think of breach of contract. Okay, that is unlawful termination.
Yes, and there was some other things that came up, changes, and of which in the changes that came up, there was a notice that was brought on board, which also had its own facts, bringing the aspect of payment in contention.
Yes, that means these guys, if so you guys are approving payment, simple as that. So you also make your own receipts, concoct information. So the right cause of action is unlawful termination of a lease agreement. So look at the circumstances under which the lease agreement can be terminated. But the fact is, plaintiffs, you have a bad case. May not want to lie. Kahiri changed the user clause without consent of the leaser. So what do you expect? I has to beg. Okay? Otherwise, it has no right. But that's what we're going to do. Variation will apply, but for now, even variation that's negotiation. Okay, what you're going to do, you'll argue, okay? You'll argue that this client of yours has not yet started utilizing that land. He's just trying, okay? So Gambe, Feduna Chusa, user close or okay? So guys, let me wish you the best. Let's
Council.
Yes.
Council, wait just a minute.
Yes.
Now, as my colleague has mentioned, they sent an instruction saying that you have been paying ground rent to Uganda Land Commission. Do we also need to ask Uganda Land Commission as a defendant?
You need to do what?
Do I also need to add the Uganda Land Commission as the defendant, since they said you have been also paying a ground rent to
those facts were changed. It is Kampala District Land Board.
Yes, Kampala District Land Board is the leaser. But now, according to the facts they sent, it's saying we should assume that we have been paying rent to Uganda Land Commission, not to the District Land Board.
It is okay. You should put Kampala District Land Board as a party. And the commissioner, but don't put the commissioner and registration. Do you have fraud anyway?
Pardon?
You're going to sue Kampala District Land Board and Uganda Land Commission.
Yes.
Yes.
Okay, thank you.
Okay, well.
Yes. Thank you. So should I work on it and upload tomorrow? Yes. You can generate it. Check something here, the stats.